they didn't like what he did.
They didn't. They did not like what he did.
We are the Arms Attorneys. Today we're going to discuss a jury of your peers, why that's something of a misnomer, and our experience as trial attorneys in what that really means for your self-defense case. Before we get started, show your support for the Second Amendment by hitting the like button. And today's episode is brought to you by our friends at Sonoran Desert Institute. If you're looking for continuing education on gunsmithing, armor courses, so much more, check them out at www.sdi.edu/armed-attorneys. Today's episode is also brought to you by LAS Carry. Loaded and Safe Concealment makes quality holsters for casual daily carry and hardcore shooters alike with their precision-formed Kydex gear. Their proprietary moldings are CNC machined to give their products a unique feel while raising the level of quality. LAS has been combat tested by special forces and overseas operations. With inside and outside the waistband options available and crazy customizations for thousands of light and magazine combinations, all made right here in the USA. So support the show and check them out at lasconcealment.com. Leslie, you've tried lots of cases.
Yes.
Right?
Mm-hmm.
What did you do before you were a gun lawyer?
I was a prosecutor in Galveston County for about 3 years.
Okay. I too was a prosecutor in Galveston County before I became a gun lawyer. Lots of trials under our respective belts. We still try plenty of cases. So we're going to talk to you a little bit today. We just had a couple recent jury wins, right? Jury trial wins.
Yep.
So a couple acquittals in the courtroom, which is great. And, you know, we like to pat ourselves on the back and say, we're the best lawyers in the world. We did it. But really, so much of your self-defense case depends upon not what you did, not what we did, but the specific people who are sitting there judging you.
Right.
So the next time you say, I'd rather be judged by 12 than carried by 6, maybe think back on this video and think about how scary that is. So first topic, Leslie, how do we pick juries?
Yeah, so it's actually a jury deselection. So in Texas, we have what's called voir dire. It's my understanding everywhere else in the world, it's called voir dire.
We're special down here in Texas.
Right,
Voir
exactly. Voir dire. Yeah. And essentially what it is it gives the judge, the state, and the defense an opportunity to speak to typically either 65 to 95 people, depending on what type of case it is, and see what their views are. And that's actually how I start most of my voir dires is by talking about biases. And, you know, people always think that it's a bad thing, that we don't want to talk about the fact that we're biased, we're prejudiced. But there are certain things that we feel strongly about. And that's what we as attorneys have to ask questions about. A lot of those questions have to do with constitutional rights. So, for example, our clients always have the Fifth Amendment right to not testify at a trial. And I need to know, is a juror going to hold that against my client if my client does not get up on the stand and tell their story, even though they have a constitutional right to not say a thing? And honestly, in most trials, defendants don't testify. That's pretty common. And that's all we have to find out is someone going to say, you didn't get up on the stand and therefore you are guilty. I don't care what else happened. That's it for me. And so it's actually jury deselection. So we don't go in and say, hey, we want you, we want you, we want you. We go in and say, we don't want you, we don't want you, we don't want you.
And the scary part is that means like the jurors that you like, that you, if you could pick them, those people are not going to end up on your jury because if Leslie and I like them, guess who doesn't like them?
The state.
The other side, right?
Exactly.
And they get to cut people from the list too. So we're basically just both frantically cutting people from a list. We only have so many people we're allowed to cut, and the remaining people make up your jury. And I will tell you, those people are terrifying because those are the quietest people in the room. The people who talk, right, are the ones who say something where Leslie and I say, ooh, I didn't like that at all. Or the state says, ooh, I don't like that he or she said that.
Right.
And so you end up, I mean, I can tell you probably 95% of the time when the clerk or the judge reads out that jury roll and they start stepping forward, I'm like, I don't even recognize those people.
Right. Yeah.
I don't remember anything about them.
Who was that person? What did they say? And they probably said nothing.
They probably said nothing. So if you're wondering how to not get yourself on a jury, the answer is just talk. Answer the questions. Raise your hand during jury selection because inevitably you will say something that one side doesn't like. But realistically, we are allowed to strike people. We strike people for any reason that's non-discriminatory, right? So I cannot strike you for your race. I cannot strike you for your religion, for your gender, things of that nature. I can strike you because I don't like the shirt you're wearing. I mean, gosh, there was a woman who, Leslie knows, where our last trial showed up in boots that I thought were horrendous for Houston in the month of June. And I said, this woman is an idiot. She's wearing leather boots up to her knees. We don't want her on our jury. And we struck her.
Right.
You know,
Exactly.
she's an idiot.
Yep.
Well, she also did other things. But I mean, it could be any reason that's not discriminatory. It could be they smiled at the prosecutor or they gave me a stink eye, right? I mean, it could be anything. So.
And that is why we have two people who do jury selection, because if I'm up there talking to the jury panel, Emily has to take down notes because obviously I can't take down notes and pay attention to what everyone's saying at the same time and pick up everyone's body language, which a lot of times some people aren't brave enough to raise their hand and say in front of their 65 new best friends, yeah, no, actually, I would hold it against someone if they didn't testify. But if someone else says it, they might go. And then that's when Emily comes in and says, oh, you know, they were nodding along. The body language is just as important of what actually people say.
You get these people in your jury. And we like to think, right? Oh, you want gun people, right? And Leslie and I ask lots of questions about firearm ownership, about carry, about whether or not you're in, organizations like Gun Owners of America, NRA, things like that. Here's the deal, though, is that we don't want people who are anti-gun, right? We ask lots of questions about like, does anyone here think that only police and military should be allowed firearms or something to that effect? Of course, we don't want those people. We also don't want people who are, I have my LTC and I carry every day and I go to train at the range once a month. And because y'all are just the worst. You really, really are. I mean, and it happened at this last trial we had, right?
It
so
did.
Do you want to discuss that a little bit?
Sure. Yeah. We had a juror who actually ended up being the foreman of our jury. And he was very open with the fact that he was a gun guy. He has his license to carry. He has guns and he does everyday carry. And I would say that he judged our client much
more harshly.
Much more harshly.
Now, they still acquitted him, which is interesting because what was interesting talking to the jury is they didn't like what he did.
They didn't. They did not like what he did.
No, I mean, they basically said that guy should never have died. He should never have been shot. However, we just don't think the state proved it wasn't self-defense.
Right.
But yeah, he was probably the harshest critic. Like, look, I carry, I have a gun. I've thought through these scenarios. I never would have done that.
That was what got me, was that he said, I never would have done that.
Yes. And I mean, I tell you, the murder case that I tried before this murder case, same deal. Foreman of the jury had an LTC. He said the exact same thing. He said, I carry, I never would have done what your client did. And that jury convicted him. And that's, I think, kind of the meat of what we wanted to sort of talk about today is, so we've got these two fairly recent murder cases, very different facts, right? But both involving shooting an unarmed man. However, I would say the facts of the case where the client got convicted were way better than the facts of our most recent case, right?
I agree.
Just objectively, we're talking about shooting a stranger versus shooting someone that you know and has been in your family for many, many years. Shooting one shot in self-defense versus shooting 12, right? I mean, just objectively, if you're ticking down a sterile list of self-defense facts, those self-defense facts were way better. And that jury convicted that client. And here's the thing, y'all, that jury would have convicted this most recent client.
I think so too.
Yeah.
I definitely think so. And that just goes to show.
No, it would nothing to do with anything else, right? Just that jury and the way they thought and the way they analyzed. And I mean, like this recent jury, what would they have done with that last case?
They probably would have found him not guilty.
I think they would have found him not guilty.
I think they would have too.
So, I mean, you get these people together and they start talking and they start thinking. And then, I mean, by the grace of God, this last jury was essentially like, look, it's a really high burden. It is a really high standard to disprove self-defense.
Right.
And that's where they sat and they really did their job and they really followed the law. You're not going to get that every time.
No.
And that was, I mean, Leslie won that case in jury selection. And that's the case a lot of the times. It's not going to matter what the arguments from counsel are, what the judge says, how well you testify, whether you do or don't testify. If you don't get the right 12 people on that jury, you're sunk.
I agree. I completely agree. And what was interesting too was in the last case that we tried, the jury deliberated for almost 9 hours. They deliberated for a whole workday
Oh,
essentially.
yeah.
And as statistics kind of show, the longer a jury's out, the better it is for the defense. And as the time ticked on, I mean, Emily and I were shocked that they were still out. And what was really interesting was that it went almost 5 hours past the 5 o'clock hour.
Yes.
So what we see a lot is that we get what we call 5 o'clock verdicts. So it gets close to 5 o'clock. Suddenly the jury all has the same agreement and they've come to a decision, mostly because they want to go
They want
home.
to go home.
And our jury in this last case took their job so seriously that they told the judge they did not want to go home. They wanted to stay there and they wanted to keep deliberating. And they deliberated for almost 4.5 more hours after
Yeah.
5 o'clock. And in the case where they found him guilty, they deliberated for
Oh, gosh. Less than 3.
less than 3 hours.
It was very quick.
Yeah. And so that just goes to show, I think, and really when talking to our jury from the last jury, it seemed like at some point they were kind of at the guilty part and that they actually looked at all of the evidence and went back through it and kind of talked it all out over that 9 hours and determined that, nope, the state had not met their burden. But not every jury is willing to do that. Not
No.
everyone takes their jobs that seriously. And I mean, obviously, we really appreciate that.
No, but ultimately, juries are wild. You can have the best defense attorney in the world, and if you get a bad jury, you are sunk. So, Leslie, what's our takeaway?
Even if you act in the most honest self-defense, even if you have the best self-defense facts, if it comes down to a jury trial, it is always a 50-50.
Yes.
And to be honest, if you have an attorney who tells you that it's anything more than 50-50,
get a new attorney.
I'd be concerned.
Yeah, no, because I mean, that is absolutely ridiculous. No attorney can ever tell you that they know exactly what a jury is going to do with your case. I mean, my advice is you win every fight you don't engage in.
Correct. Right.
So if you can do anything but shoot someone in self-defense, right? Even if you're not legally required to retreat in your state, if you can retreat, if you can get yourself out of a situation, you've got to do it. The chances that you wind up at a jury trial and then all bets are off and it's all about 12 people who didn't want to say anything during voir dire should terrify you.
I mean, those are the 12 people who aren't bold enough to stand up and speak their truth or speak their views on things. And those are the people that you're leaving your future. And if you're charged with murder, you're facing life in prison.
Oh, yeah.
So the rest of your life, you're leaving in the hands of 12 people who essentially weren't willing to stand up and say what their views are on certain issues.
All right, thanks for watching. Let us know what you thought about this video. Do you like seeing more of Leslie? Do you like more war stories? Do you like more self-defense cases? Let us know what you want to see in the channel in the future. And until next time, we're the Armed Attorneys. Well, we hope we terrified you this episode.